Good morning and good afternoon, depending on where you are, and welcome to the third and final webinar in our commercial litigation series, What If I Can't Perform My End of the Deal, Force Majeure Clauses, and Frustration. Thank you everyone for tuning in today. Please take note of the information slide that is on your screen while I introduce myself and our distinguished speakers for this final session. Should you have any questions arising from this session, feel free to submit them in the questions tab. We will try to address them at the end of this session, but if we run out of time, feel free to reach out to any of us and we'll be happy to answer your questions after the webinar. My name is Nabila Abdul Malik, and I'm a partner at the Fasken Ottawa office. I'm qualified in 4 jurisdictions, England and Wales, New York, Ontario, and Malaysia. My practice focuses on litigation, arbitration, international trade and investment, as well as white-collar defense. I am joined by my litigation colleagues from across Canada. The first is Rahat Godil, who is a partner at Fasken's Toronto office. Rahat is a business-minded litigator with a diverse practice in litigation and arbitration, with a focus on complex and high-value commercial and contractual disputes. The second is Daniel Byma, who is a partner from our Vancouver office. Daniel's broad litigation practice focuses on commercial disputes, including real estate cases, breach of trust and fiduciary duty claims, contract cases, oppression claims, shareholder disputes, and fraud claims. Our third speaker is Christine Provencher, a partner from our Montreal office. Christine has experience in major civil and commercial litigation cases. She represents clients in all types of contractual disputes, primarily in the construction industry. Thank you, Rahat, Daniel, and Christine for joining us today. So the timing of this session is quite fortuitous given last week's freezing rain and major power outage in Quebec and parts of Ontario. And of course, due to the COVID-19 pandemic and its aftermath, some consider both force majeure and the doctrine of frustration to have entered into their heyday, and affected parties have considered relying on these doctrines to relieve themselves of their contractual obligations. So let's get started. First, please provide us with a general understanding of force majeure and the doctrine of frustration. And then please explain the recent developments in case law or the recent interpretations of these doctrines made by the courts in your jurisdiction. How has the law been interpreted or applied during the pandemic? Let's start with Rahat, who will explain force majeure in common law. Daniel will then explain the doctrine of frustration in common law, and Christine will explain the equivalent in civil law.
Thank you, Nabila. Force majeure really is a contractual doctrine. Force majeure clauses are provisions parties often include in their commercial agreements because they serve as a risk management tool. They're really an exception to the general principle that parties must perform their contractual obligations. The reason for this exception is that in any business transaction, a party may encounter some unexpected event outside its reasonable control that might impact its performance. And force majeure clauses basically act as a risk management tool. Like I said, they allocate the risk of these events that are not within the control of a party. They generally will discharge a party from its obligations and will excuse its performance when it has either been delayed or prevented altogether because of something extraordinary. And that really is the key piece. The event has to be something that's extraordinary, something outside your reasonable control, something outside of your normal business risk. For example, a pandemic, a war, fire, some kind of natural disaster, something that you did not have control over. And it's prudent to include these types of provisions in your contract, and they do tend to be actually heavily negotiated, because if you don't have it in your contract, force majeure isn't something that can be implied. My colleague Daniel will be speaking a little bit later about the doctrine of frustration, but force majeure is different from frustration in that sense that it's not something that can be implied. It is something that you have to think about and include in your contract. Where you have included it in your contract, generally what a force majeure clause will do is it will set out what events are covered. So what is the definition of force majeure? What constitutes a potential force majeure event? And then what happens if that event actually becomes reality? what are the parties' rights and obligations in that situation? You may see notice requirements in your clause. You may see mitigation responsibilities in the clause. There may be a duty to mitigate. There may be scope of what that entails, when notice has to be provided, and also you may want to include what potential relief is available if there is a force majeure clause. So, for example, does the agreement terminate because there's force majeure, or is performance simply delayed for a certain period of time? If a party wants to rely on force majeure, they will really have to demonstrate that the issue that you're relying on is covered by the clause and defined as a force majeure event, that there are no other reasonable alternatives to perform your obligation, and that you yourself are not responsible for the failure to perform. If you're in a situation where performance has simply become a little bit more difficult or a little bit more expensive, that typically is not grounds to successfully invoke force majeure. So those are some general principles. And Nabila, you did ask about cases and how does this play out in court. Typically, what we see is that a force majeure clause is relied on by a party in two sort of circumstances. It's either a party that there's an event that occurs, and the party wants to say that, well, they're entitled to terminate the contract and or suspend performance, and that party may go to court bringing an application and seeking a declaration that this particular event entitles them to terminate the contract or get out of their obligation. That's one scenario. And another potential scenario is that a party is not performing their obligations, gets sued by their counterparty, and then raises force majeure as a defense to their failure to perform. The applicability of force majeure clause to any event really is a pretty fact-specific exercise, and a party, in order to successfully invoke it, has to show that they fit within the defined event, and has to really kind of follow. You have to see what the clause actually provides in order to take the benefit of it. And that was the case, I would say, prior to COVID, and that has been the case since the pandemic as well. So there hasn't really been a major shift, I would say, in terms of the general broad principles relating to force majeure in recent years. But what we have seen over the last few years certainly is a number of cases arising in the context of COVID that courts have now had an opportunity to deal with. And so you can now see how courts have applied the specific wording in parties' clauses to COVID and the closures that led to it, and how that impacted the obligations of the parties. And I will briefly discuss two cases. They're both Ontario Court of Appeal cases, one of them from earlier this year, one from last year, both arising in the context of commercial leases and force majeure clauses in those leases and how they were interpreted because of the COVID pandemic. The first one is Niagara Falls Shopping Centre and Laugh Canada Company. This was a case that involved Laugh Canada renting a unit in Niagara Falls Shopping Centre to operate an indoor fitness facility, and under the lease, obviously had to make monthly rent payments. During COVID, as a result of government lockdowns, when all non-essential places were closed down, Laugh's fitness center also was closed down. And in that context, Laugh actually stopped charging its own members for their membership fees. And as a result, was suffering financial hardship, couldn't pay its own rent, and eventually stopped paying rent to the shopping center in which it was leasing its facility. In response, the shopping center ended up bringing an action for breach of contract and sought all unpaid rent from Laugh. Laugh ended up arguing that it didn't have an obligation to pay rent because the closure amounted to a force majeure event. And what I have up on the slide here is just the force majeure, wording of the force majeure clause in that lease. And you can see that the clause in that context provided that if either party is delayed or hindered in or prevented from performance of any act required hereunder because, for example, restrictive laws or any other reason, similar or dissimilar, beyond the reasonable control of the party, financial inability accepted, performance of such act shall be excused for the period of delay caused by the force majeure event, and the period for the performance of the act shall be extended for an equivalent period. And then the clause went on to say that delays or failures to perform resulting from lack of funds or which can be cured by payment of money shall not be force majeure events. So that was the clause in that particular lease, and the court below, in interpreting that provision, said that the landlord was exempted from performing its own obligation and didn't have to provide the tenant with the premises during the closure, but the tenant was required to pay rent throughout. LAF understandably appealed that decision, and the Ontario Court of Appeal allowed the appeal in part. The Ontario Court of Appeal also held that, yes, the force majeure clause did excuse the landlord's failure to provide rent, but then went on to say that the landlord had to extend the lease for that period of time during which it wasn't providing the facility to the tenant. The Court of Appeal also said the tenant was obliged to pay rent during the closure, but did not have an obligation to pay rent during the extension period. And in coming up with this decision, what the court basically said was there were two components to the operation of the force majeure clause. First component was that the party has to be delayed or somehow prevented from performance of something under their contract. And the second component is that the failure to perform has to be because of an event that constitutes basically force majeure or fits within the definition of force majeure in the contract. The court said that both of these components were satisfied for the landlord, but only the first component was satisfied for the tenant. And what the court relied on really was the fact that this clause expressly excluded the financial inability as a force majeure event. And it also expressly said that failure to perform as a result of lack of funds or something that can be cured by payment of money will not constitute force majeure event. So that was the first case. The second case, briefly, is the Windsor-Essex Catholic School Board case with a numbered company, also a commercial lease agreement case. In this case, a school board was renting a facility, renting premises from a sports facility for running sports programs for students. Again, during lockdown, we're not able to use those premises and eventually stopped paying rent. And in that case, it was the tenant who went to the court and sought a declaration that there was a force majeure event and that they no longer had to pay rent during that period. You can see on the slide here that the clause in this particular case said, in the event the landlord claims a force majeure has prevented the landlord from enabling the tenant to make use of the leased premises or operate its programs in the center, then rent and additional rent shall fully abate during such period until the landlord has restored the ability of the tenant to use the premises and operate its programs. The application judge in this case held that the force majeure clause applied, and yes, the rent was abated, but the landlord ended up appealing and said that no, that wasn't the right interpretation, arguing that this clause really turned on the landlord claiming an event to be a force majeure event. So essentially what they argued was that the initial part of this clause, which says, in the event the landlord claims force majeure, that hadn't been triggered because the landlord said, well, we never said that there's a force majeure event. This was not taken well by the courts at the lower court or the Court of Appeal. Both courts found that really the triggering event in this case was the lockdown. The lockdown did result in closure of the appellant's facility. the landlord's facility. And once there was that closure, it could not provide that facility to its tenant and did not provide that facility to the tenant. And once that happened, then yes, the tenant no longer had an obligation to pay rent. So I'll stop there, but I just want to note, I think what we see from these cases is that force majeure clauses tend to be interpreted like any other clause within your contract. Whether or not they are triggered and whether a party is successful really depends on the nature of the event and really does depend on what the wording of the specific clause is. And courts do look very closely at the express words in the force majeure provision. They read the provision as a whole in its entirety. How does it fit in with the rest of the contract? And then really are reluctant to improve the bargain for one party at the expense of the other party, but also want to make sure that the interpretation makes sense and is not commercially absurd. So I'll stop there.
Thank you, Rahat. So the next piece we're going to look at is frustration. And this applies if a particular commercial contract does not contain a contractual basis to terminate, such as the force majeure clause, or if the particular facts preventing performance do not constitute force majeure under the contract. Then a party can seek to rely on the common law doctrine of frustration. Frustration arises when there's an unforeseen supervening event which is not contemplated in the contract by the parties. The event itself arises after the contract is entered into. The event cannot be the fault of either party. It's something that occurs independent of the parties, either by a third party or something natural like the pandemic. And the supervening event has to render the performance of the contract radically different from what was to be undertaken by the parties under the contract. Typically, the question of whether a contract is frustrated will turn on that last requirement, whether the event renders the contract radically different from what the parties contemplated. This is a very high bar in the case law. Historically, the courts limited frustration to events that rendered performance physically or legally impossible. The modern doctrine has expanded beyond that to include radical changes to performance of the contract. But those early cases dealing with impossibility still kind of govern and influence the courts and requiring that the contract essentially be incapable of performance. It's a very high threshold. It's also not typically sufficient that performance be radically changed for a short period of time unless the contract itself is only for a short period of time. If the change is not permanent, the courts may not find frustration under the contract. The phrase that you see bandied around in the case law is that the change can't be transient or temporary. It has to be a permanent change. So if a party can meet this high threshold of frustration and the contract is brought to an end in the sense that both parties are released from further obligation under the contract from the time of the supervening event, this does not mean that parties are absolved of obligations leading up to the supervening event. And so if there was expenses incurred, for example, in manufacturing under the agreement up to the supervening event, there may still be a claim for damages or expenses related to the performance up to the event that causes the frustration. Turning to the next slide. Much like force majeure and what you heard from my colleague Rahat is that there is a careful contractual consideration that is still required for frustration. And what's required there is to determine what the purpose, the underlying purpose of the contract is and what the nature of the contract is. And then a factual analysis to determine whether or not the purpose of the contract has been frustrated. So the courts will look closely at the contract to determine the nature of the services being provided, and then examine the event in detail. And they'll look at all manner of factors that can affect the contract, including the severity of the impact of the event, how long the impact will last, whether the contract itself deals with allocation of risk, either directly or indirectly, that may address the event at issue. As I alluded to earlier, this is a high bar. It's generally not enough to show that profitability is affected, even if the profitability is significantly affected by the supervening event. It's also not enough to show that the contract has become difficult or burdensome to perform. it truly does need to be something that fundamentally changes the performance of the contract. Essentially, the courts are very hesitant to relieve parties of their contractual obligations unless there's a really compelling reason to do so. And we can see this in the case law that I'm going to address on the next slide here, including recent cases that deal with claims of frustration arising from COVID. So I have a smattering of cases there that I'm going to kind of take a high-level overview to show just how high a bar frustration is. And one thing that you see in a lot of these cases is that frustration is brought as an alternative argument a lot of the time. Parties seeking to get out of a contract will often rely on the force majeure provisions in their contract if they exist, and then try and rely on frustration in the alternative. And so there's unsurprisingly overlap in these principles and the application of them. So the first case that you see there is the Interfor Corporation against Mackenzie Sawmill. And this is a 2022 BC Court of Appeal decision dealing with a contract for the production of wood chips. The sawmill at issue was damaged and then destroyed by a series of fires. And they stopped producing wood chips under the contract pursuant to a force majeure provision that was in the contract. A new mill was eventually built on the property, but it was built and owned by companies associated with the original sawmill, not the party that was under the contract at issue. And that new mill sold wood chips to third parties at higher prices than what was contemplated in the contract between the parties in the litigation. When the original purchaser caught wind of these higher prices and the fact that the sawmill was now producing under another banner, they brought a lawsuit to enforce the original contract. And the mill defended on the basis of the force majeure clause in the contract and alternatively frustration. And what the trial court held and the Court of Appeal upheld is that the mill's obligations were not permanently discharged under the force majeure provision, and the contract was not frustrated, because the frustration piece is what I'm going to focus on here. There is no frustration because of the foreseeability of the event that was dealt with in the force majeure clause. The parties turned their minds to it, they put it in the contract, and so frustration wasn't available to the parties in those circumstances. But the court went on to go further and said, even if the force majeure clause did not apply, the events did not totally affect the purpose and the nature of the contract. It only suspended the mill's ability to perform. Essentially, they said the mill had an opportunity to rebuild and could eventually resume its operations and continue to sell the wood chips as originally contemplated under the agreement. And so what we see here is both the importance of the unforeseeability, but the high bar that's required for frustration, in that a fire that takes out an entire sawmill that requires months or maybe even years to rebuild is not sufficient to find frustration under the contract. The next case there is the Brayberry Development Corporation against the Gap. And this is a 2021 Ontario Superior Court decision that deals with a retail clothing store lease. In the early days of COVID, government restrictions in Ontario required the Gap to shut down their store for 2 months from the end of March to the end of May. And the Gap elected to not pay rent in April or May of that year, and then chose to unilaterally pay reduced rent from June through September. They then vacated the premises in September, and the landlord brought an action to recover unpaid rent for that period. The Gap argued force majeure and frustration as defenses, and the court held that the force majeure clause did apply, but that it expressly did not relieve the Gap of its obligation to pay rent under the lease. And so then the court went on to say, with the parties having turned their mind to it under the contract, frustration could not apply in that instance as well. Again, the court went further to say, even if the force majeure clause was not there, the government shutdown was not sufficient to rise to the threshold required for frustration. It didn't radically alter the purpose of the contract. The lease agreement did not require the Gap to continue to operate the retail space during the lease, only that it continue to occupy the space. And so the court held that the temporary and transient nature of the shutdown was not sufficient to render the lease radically different. And so again, this case highlights the importance of the unforeseeability and the high threshold of finding frustration. In this case, the Gap's store was essentially transformed into storage for a couple months, and that was not sufficient to undo the purpose of the lease. The next case is the Ambrosievich against Zhang case. And this is another COVID case that arose with this, instead of the lease, which is the most common case we've seen in COVID, it's with the respect to the purchase of a residential property. And what happened there is 4 days before closing, the buyer tried to extend the closing until she could become a permanent resident to avoid the foreign buyer tax here in BC. The seller declined and the buyer decided not to proceed. And the seller brought an action for payment of the deposit out of trust. There was no force majeure provision in this case, and the buyer argued that the contract was frustrated because the COVID restrictions prevented her from coming to BC to complete the sale of the property and to become a resident to avoid the foreign buyer tax. And the court held that there was no frustration and that the restrictions in place at the time did not radically alter the purpose of the contract. They found that it might have been more costly for her to perform with the foreign buyer tax and more difficult to close from abroad, but the contract was capable of performance. The KS Slater case is a unique case where there was a lease that allowed a tenant the right to sublease a portion of the lease premises if certain conditions were met. One of the conditions was for the tenant to provide written confirmation from the federal government that the federal government their federal government funding had been lost or was expected to be lost by a specified date in the spring. Because of COVID, the government did not issue their spring budget on the anticipated timing under the contract, and the tenant did not have written proof from the government of their anticipated loss of funding. The tenant nonetheless sought to exercise its option to sublease, which the landlord denied on the basis that the conditions weren't met. The tenant argued that the contract was frustrated by COVID and the subsequent government budget delays. Now here the court rejected the argument and held that the parties turned their mind to the timing of the option and that the contract clearly allocated the risk of the potential timing issues with the government budget on the tenant. The parties knew that the timing of the new budget was in the spring and that budget could be delayed for any number of reasons, including the pandemic that eventually rose. And so the court held there that there was no frustration in circumstances where the parties turned their mind to that possibility and allocated risk accordingly under the contract. The last case I put in there is actually an older case. This is the Petrogas processing. And I wanted to put in a case where frustration was found to exist under the contract. And this is a 1989 Alberta case. And what happened there is after the parties entered into a gas purchase contract at set prices, a price regulation scheme was introduced by the government, making the pricing scheme between the parties illegal. It made it impossible for them to comply lawfully with the pricing under the contract. And so the case there turned on whether or not the new scheme frustrated the contract entered into by the parties. And the court found that it did. They found that the supervening illegality of the regulatory scheme frustrated the contract. And the court went on to also find that the contract was frustrated on the broader ground that price regulation made performance of the contract a fundamentally different thing than the parties had agreed to. Because it did not just render performance by one party more expensive or onerous, but also destroyed the commercial basis of the agreement. So what we can see from these cases, and they are is that they're fairly representative of the high bar in persuading the courts that a contract is frustrated. And towards the end of this presentation, after my colleague Christine will talk about some key takeaways. But preliminarily, the law of frustration highlights the importance of trying to address potential events that could disrupt performance of a contract in advance with force majeure clauses or other termination provisions. So I'll now turn it over to Christine to discuss the applications of these principles in Quebec.
Thank you, Dan. Good morning and good afternoon, everyone. As you will hear from me talking, you'll all see that English is not my mother tongue, so I might have to rely a little bit more on my notes. Please bear with me. So, force majeure, or as the Quebec legislator decided to translate it to English, superior force, is actually a principle that was codified in the Civil Code of Quebec. And under Article 1470 and Article 1693, which we'll see on the next slide. As you will see, however, although it is codified, although it's part of our legislative body here in Quebec, the main characteristics of superior force or force majeure somehow falls between the common law doctrine of force majeure and of frustration. And so you'll see a lot of similarities with what I'm going to tell you about and what Rahat and Dan just told us about. As provided for Section 1470 of the Civil Code of Quebec, superior force allows a person to free himself from his liability for injury or damages that may be caused to another person by proving that the injury or the damages result in superior force unless the person has undertaken to make reparation for it. As you will see in a few moments, 3 criteria must be met for a person to successfully free himself from liability, and namely the event, and as we can see them from the article, the event must be unforeseeable, irresistible, and beyond the party's control. Force majeure or superior force is a bit different under civil law, as you can use it to either as a means of defense against extra-contractual liability, so what we would call tort under common law, or to discharge a party from its contractual obligations. If we turn on over to the next slide, we'll see Section 1693 of the Civil Code of Quebec specifically applies to contractual obligations and how a party may be discharged from applying them in the context of a contract. So this section provides that the debtor of a contractual obligation can no longer perform its obligation because of force majeure or superior force. This person will be released from liability or from the obligation to perform unless the debtor, so the person, has expressly assumed the risk of superior force in its contract. As it says in the section, the burden of proof of superior force is on the debtor. And again, you'll hear a lot of repeating here. It is a very high bar. So 3 criteria have to be met in order to successfully argue the force majeure defense. The first criteria is the event must be unforeseeable. How do the tribunals interpret the unforeseeability of an event? One must look at it through the lens of a reasonable person. At the time of the creation of the contract, this reasonable person must not have been able to foresee the event at that time. It does not mean that this event must never have happened in the past. It's something that may have happened to the past, but could not reasonably be foreseen in the same situation when the parties decided to contract. The second criterion, the event must be irresistible. This is probably the hardest to meet. It means that, again, you'll see in Quebec law, we love to use the reasonable person, and we have a lot of reasonableness in our various tests. So this test is when a reasonable person in the same circumstances would not have been able to take measures to prevent the event from occurring. Both doctrine authors in the case law consider that the irresistibility essentially means that the event must have made the obligation impossible to perform. The irresistibility requirement is not meant when it just becomes merely more onerous, perilous, or difficult to perform the debtor's obligation. The third criterion is beyond the control of the debtor. It's sort of, I would say it's a bit repetitive with the second one, but it means that the event must be outside of the usual scope of the debtor's activities. The evidence must show that a defendant who invokes force majeure was not negligent in performing its obligations. And normally the courts will expect a demonstration of perfect or almost perfect behavior in the context of the force majeure event. what happens if someone manages to demonstrate force majeure and to successfully invoke force majeure? Well, if superior force is proven, the debtor of the obligation, and we can see those on the next slide, Andrea. So if superior force is proven, the debtor of the obligation may be fully discharged from it or may be allowed to suspend the execution of its obligation. In case of a suspension, so temporary suspension of the execution, the debtor of the suspended obligation must immediately resume performance as soon as the force majeure event is over. In such a case, the debtor of the obligation would not be responsible for delays. So we're talking about, as Nabila said in the beginning, I worked a lot in the construction industry, and so delays is a main part of this. Delays would be excused in such a circumstance, or if damages are caused in relation to the termination of the contract, the debtor of the obligation would not have to pay for those additional damages. However, conversely, the creditor of the obligation, so the counterparty to the contract, will also be released from the performance of its correlative obligation, so most likely payment. And if payment had been made in advance, the debtor of the obligation who invoked force majeure will have to reimburse such payment that had been made before. If we look at a bit of recent case law on force majeure, you'll see that, I'm sorry, I missed it. I went a bit too fast. So other events, other points of interest, the qualification of superior force, just like Rahat mentioned earlier, is fact-driven. So it will depend on the specific circumstances of each case. Not all floods, wars, fire protests are considered to be superior force. In fact, as Nabila mentioned earlier, we did in the province of Quebec in Ontario, we were hit by a major ice storm just last week, causing in Quebec, for the most part, major power outages all over the province. And I myself suffered from a 4-day outage, power outage. And although I could have been tempted to argue force majeure in order to be discharged from my obligation to prepare for this discussion today, I quickly came to the realization that I would never be able to meet the irresistibility criterion, knowing that the office had electricity where I could duly perform my obligation. So it is a very high bar to meet. And superior force is not what we call of a public order. Public order are a set of rules that nobody can move away from. So even in your contract, you may not alter some the public order obligations that were set by the Quebec legislator. Superior force is not considered to be of public order, and the parties are free to change, alleviate, waive superior force in their contracts. And as you'll see, we often recommend to our clients to negotiate and adapt a superior force measure to their own contracts in order to mitigate and allocate risk among themselves. So now actually going to the recent case law on force majeure, in Service Ricova versus the city of Chambly, Ricova is a recycling company that entered into a 5-year fixed price contract with the city of Chambly to collect, transport, and sell, or valorize, as they call it, the recyclable materials collected on the city's territory. However, as of 2018, China adopted a series of measures to restrict the importation of recycled goods on its territory, which resulted in a major drop in the value of several recycled products that were previously sold on the Chinese market. Because of this drop in the value of the materials that were sold to China, Ricova had to renegotiate its own agreement with the operator of the sorting center and pay additional and unforeseen costs to valorize the recycled materials collected in the city of Chambly. Recover argued that China's measures and the resulting drop in value were akin to superior force and asked the city of Chambly to renegotiate their agreement, which the city refused to. Before the court, Recover filed an action against the city of Chambly and claimed that the city should assume those additional costs because of this force majeure event. Both the Superior Court of Quebec and the Court of Appeal of Quebec, which is the decision you see in front of you today, concluded that the criteria of superior force were not met. In fact, according to the Court of Appeal, the changes in the market were neither unforeseeable nor irresistible. Market fluctuations in any agreements can be foreseen and mitigated, according to the Court of Appeal. In that specific case, those courts found that Recover had benefited from favorable market conditions for almost the entire part of the contract, the entire duration of the contract. And also, Recover's agreement with the operator of the sorting center specifically included a price adjustment clause in case of a market fluctuation. So Recover had to be aware of the possibility that its own contract with the city of Chambly would be impacted should this clause be triggered. Finally, both courts found that China's market fluctuations did not make the obligation irresistible. It was not impossible for Recover to render their services. In fact, it was just more expensive, more onerous. And as I mentioned before, it does not make it impossible to perform. In the second case I'm going to talk about it's a very recent one from the Superior Court of Quebec in the context of the pandemic. Again, you'll see some sort of undercurrent here with the decisions we're talking about. It's in the context of a leasing agreement. The Quebec Inc. company versus Stationnement Safeway Canada. The plaintiff, the Quebec Inc. is a corporation specialized in real estate management in Montreal and owned at that time 2 large commercial buildings downtown Montreal and the adjacent parking lots. Safeway Parking Canada is a corporation operating parking spaces. And in 2016, the parties concluded a 4-year lease for a downtown parking lot with an end date of June 30, 2020. As you all know, on March 13, the government of Quebec, as like most of the provincial governments in Canada, declared a public health emergency in the province. Regular business was essentially shut down or halted, and downtown Montreal was emptied out. On March 25th, the tenant informed the landlord that although it intended to continue to use the parking spaces that it was renting, it had the obligation to suspend its rental payments and that it intended to continue to operate the parking lot, but offered the landlord to remit 80% of gross sales in lieu of payment. The proposal was never accepted by the landlord, who in turn filed a legal action against its tenant for the full payment of the agreed upon rent. The court concluded that although the COVID-19 pandemic and the government decree were unforeseeable, so met the first criterion, the irresistibility criterion here was not satisfied as the tenant was never prevented from actually paying rent. Again, the court reminded, as we see on paragraph 19, that the fact that fulfilling an obligation may be difficult and onerous is not enough to satisfy the irresistibility criterion of superior force. On the next slide, you'll see 2 cases in the context of the COVID pandemic. I have to say the Metal APS is not specifically in the context of the COVID. It's more about inflation of prices. In that case, Metal APS was a ventilation material supplier, and that argued that the steep increase in the price of steel all over the world amounted to force majeure and prevented it from complying with its obligations to sell at a fixed price amount some materials to Montreal. APS asked the court to set aside this maximum billing price in order to cover the dramatic increase in the price of steel. The Superior Court concluded that APS had not submitted any evidence that the increase in the price of steel had affected its actual capacity to deliver the merchandise, and thus had not submitted evidence of the irresistibility criterion once again. And also, it found that APS could not claim it also found that the contractual discussions among the parties had actually touched the possibility of price inflation over the duration of the period, and it had specifically been set aside by the parties in that case. So there was no chance that the court would agree to this request. Finally, very quickly, in Dazé versus the Quebec company, the plaintiff claimed damages from its former contractor who abandoned demolition work during the pandemic. The former contractor argued that the pandemic had caused important labor shortages over the province, and that made it impossible for them to finish their work. The court held that the alleged labor shortage, we have to say the evidence must not have been very convincing. The decision is quite short, but this alleged labor shortage was not sufficient to discharge a contractor from its obligations because, again, the irresistibility criterion was not met. So I cannot stress enough how high the bar is if you don't have a specific force majeure clause in your contract. Now, very briefly touching on frustration under Quebec civil law. Very quick, it is unapplicable under Quebec civil law. As you saw, it is somehow similar to our concept of force majeure as provided for in the code, but our tribunals here in Quebec have for a long time recognized that the doctrine of frustration, like unforeseeability, is unapplicable under Quebec civil law, and that was again reminded by the Supreme Court of Canada a few years ago in the Churchill Falls decision. And so, on that note, I will leave the mic back to Nabila.
Thank you. Thank you for explaining the general principles and the recent case law. So what are your recommendations to our audience today on best practices when it comes to risk allocation? Rahat, would you like to start?
Yes, sure. And I can speak briefly to force majeure clauses and drafting, and maybe I'll start by commenting on what Christine said earlier, where she thought she was going to claim force majeure to get out of this presentation today. If she actually raised it, I would tell her, well, we have no contractual agreement on a force majeure. And I think Dan would say she doesn't meet the high bar of frustration. So all of that to say, negotiating and what you say in your contract is really important and critical when it comes to your force majeure clauses. Can't rely on it if you don't have the clause. And if you have the clause, you will have to fit yourself in that clause. So it's important to give some thought at the outset to a few different aspects of the clause. Most importantly, I think you want to be careful about what's covered. So how are you defining your force majeure event? How expansive or how narrow you want that to look like? Do you want exclusions in there? You want to think carefully about that. You want to think carefully about what will be the relief or the impact if somebody can show that, yes, they fit within the defined force majeure event. Does it right away bring the contract to an end, or does it just suspend it for some time? Do you get an extension of time? How long does that last? All of those are things you want to think about. You'll also want to think about notice requirements potentially. How quickly do you want your notice? How long of a notice period do you want or are okay providing? Is there a duty to mitigate? And if so, what is the scope of that? What does that look like? What kind of things do you want your counterparty to take if they are claiming force majeure? That's another, I think, important aspect. And one other thing I think you may want to think about is whether you include something in there about if there is if there is a dispute, if there's somebody claims force majeure, the other party doesn't agree or there's in compliance with the obligations, how do you deal with that dispute? Do you come back to the table, try to negotiate and figure out a resolution? Do you go to court? Do you go to an arbitration? I think those are also things to think about as we're dealing with more and more with these types of issues and parties increasingly relying on these clauses. I think it's important to give some thought to how potential disputes will be resolved as well.
Thank you. Christine, do you have anything to add to that?
Honestly, I think Rahat made a great job. My only, again, based on my own background in construction, I have to say sometimes parties tend to ignore or tend to not think about the impacts of the notices and the delays for notices and how this whole process will have to actually go over once the force majeure has started. I would just say, please think about in practice how this notice can be sent. When are you able to do it? And the delays, especially under Quebec law, are regarded very, very strictly by the courts. So if parties do not specifically meet the requirements for force majeure and triggering force majeure events, the court will simply refuse to give rise to the clause. So I would say, although all of our recommendations are great in a general context, I have to say you clients have to make sure that it is adapted to your practical realities.
Thank you. Okay, so when an interfering or supervening event occurs that one or more parties think constitute as force majeure or frustration, how should parties deal with that? Dan, would you like to start?
Yeah, maybe if we can just turn to the next slide, I think there's some points that help address this. And this is kind of the key considerations here. The question to ask is, what are the actual impacts of the event and how does that fit within the purpose of the contract and what the parties' obligations are under the contract? And does that trigger a force majeure clause or other provision that allows for termination? And if not, if the force majeure clause doesn't apply, are there other remedies or claims that are possible? And that's really the question of frustration that I talked to earlier. Was it an unforeseeable event that the parties didn't contemplate, that was not caused by either party, that arose after the contract, and that radically changes the purpose or the party's ability to perform the contract? If there is a contractual provision that captures the supervening event, the big question is how do you engage that provision? There's typically notice requirements that under contracts have to be complied with that may specify some combination of delivery, a deadline for when the notice is delivered by, what the notice has to include, and you need to ensure that you strictly comply with those in order to be able to later rely on those contractual provisions, like the force majeure provisions, for example. And I believe Christine's going to talk to a couple of these other points here now as well.
Yeah, well, and thank you, Dan. And the other considerations one must have is once we've addressed the contractual requirements or the contractual possibilities, other external considerations must be taken. So one of them is this event potentially covered by insurance coverage? Was the claim submitted to the insurer in charge of the insurer of the defaulting party, or even of the client or the other party? Will a declaration of force majeure affect the financing of the project? I'm thinking again of construction projects where potential force majeure events may prevent or block draw requests from being approved by the bank. So if construction or if the project is ongoing, declaring force majeure when you're not 100% sure of the actual, that the requirements are met, may actually impact other components of the contract or of the project. And it's something that needs to be considered. Also, and this is more of a I'm sure it's the same in all provinces, but especially in Quebec, whenever a party intends to claim damages or to invoke a defense against damages, the tribunals will look at mitigation measures. So even if the event falls under a force majeure, and even if the debtor of the obligation may be discharged from it, it remains extremely important to put mitigation measures in place and to do everything that is possible to limit the damages to the other party. Alternatively, once everything has been done and discussions have been started and notices have been sent, one of the things that the parties need to consider is it possible to negotiate amendments to the contract? Even once the force majeure event has happened, we often see in litigation that an open-minded discussion early in the process can actually lead to a better resolution than invoking a clause or invoking force majeure in the Civil Code of Quebec. And finally, the question, is it time to litigate? And if so, what are the next steps? Are we meeting the contractual requirements for litigation? Many contracts provide for a series of steps where mediation is mandatory or arbitration is mandatory. So we need to look at this contract, need to make a decision based on the contents of the contract. And then, of course, if you didn't have the chance to do it yet, you call one of us litigation friends, and we'll be there to help you in deciding and guide you in deciding if litigation is actually the best for the situation.
Thank you, Christine. Let's talk about the consequences of invoking force majeure or frustration, the remedies and relief that can be sought and granted. Rahat, would you like to address that?
Yes, I think I mentioned this briefly before. It will depend, if you're talking about the force majeure context, obviously will depend on what you have said. So again, in your provision, and I think the different possibilities include things like you could just have a termination of the contract. Like the clause could provide that if there's a force majeure event, the contract comes to an end. So that's one possibility. Or there could be delayed, it could provide for delayed performance. And so obligations just are suspended for the duration of force majeure or a set amount of time. And then at the end of that time, you still have to deliver those obligations. So it's really, you can get creative. I think when you're drafting about what you want to include as potential relief in the event of force majeure.
Thank you, Rahat. One remedy or relief that those in the construction industry will be most interested in is in relation to delay claims. Christine, as you're familiar with construction litigation, can you tell us how Quebec courts have treated delay claims resulting from the pandemic?
Of course. Quite honestly, there hasn't been any decisions rendered in the context of delay claims in the context of the recent pandemic. So more specifically on COVID and delays, that hasn't been tested yet. However, the lessons learned from the case law in general on force majeure in Quebec show that, again, the bar to invoke force majeure is very high. And many contractors, but that being said, many contractors in the context of the pandemic, more specifically, were effectively prevented from performing their obligation. So it's either, as you all know, well, I'm guessing it was the same in all provinces, but construction sites were shut down for a period of 3 to 4 months in most provinces across Canada. And so they were effectively prevented from respecting the schedule or from complying with their contractual obligations. And as most construction contracts contain delay provisions, and provided that contractors were mindful of the notification provisions and contractual requirements for their notice of delay, I believe that many of those contractors will be in a position to demonstrate force majeure and to claim damages or extensions of delays in that context. So I believe it's hopeful for the people who suffered from the COVID pandemic. But again, we have to make sure that the contractual provisions were met.
Thank you, Christine. I see that we're almost out of time. So I would like to thank our speakers today for enlightening us about force majeure and frustration. I would also like to thank our audience for joining us today. We hope you learned something from this discussion. And should you have any questions or would like to further discuss, feel free to reach out to any of us. Please take the time to complete the survey so that we can create better content for you in the future. And if you like to view a recording of the past 2 webinars in our commercial litigation series, please visit Fasken's website and look under the section Fasken Institute. Thank you, everyone, and have a good day.